Kiran Mazumdar Shaw, CMD of Biocon, but a very eminent corporate voice nonetheless, joins us right now on the show to talk about the importance of this move. Ms. Shaw, good morning. Thanks so much for joining in. No debate that this is a game-changing move, but I want your views on how important do you think this is in terms of a lot more than what it just does for banks?
Well, I agree with Arundhati Bhattacharya that it's a great move, it's a welcome move, it's a long overdue bill that has been passed, and I think nobody can, not agree with or disagree with what the government has done, and I congratulate this government for bringing in this long-awaited and long overdue bill. But I think, she's absolutely right. I mean, we don't have all the mechanisms and the knowledge base in place to really take full advantage of such a bill. For instance, the bankruptcy bill and bankruptcy law and insolvency law has been working for over decades in the US, and maybe we should really learn from how they learn to deal with these kind of issues. Because I think the whole purpose of this bankruptcy bill or the insolvency law is really about making sure that when companies start becoming insolvent or declare insolvency, that banks are in a position to really recover as much of their dues as possible, that creditors are able to do likewise, and we need systems in place, we need processes in place. And I think this is a very important bill because it allows businesses to wind up and then the promoters and others to carry on with new businesses. I think for far too long, we have been caught in this BIFR kind of a structure or a very suboptimal kind of insolvency ecosystem, which really doesn't allow people to resolve cases and move on. I think the tendency has been for corporates to just use the courts to slow things down, to sort of make sure that debts continue to be kind of extended forever, and that's got to stop. I think banks need to recover their dues and in time. So I think these are important measures, but we must make sure that not only do we misuse it or abuse it, but we learn to know how to use it.
In addition to that, Ms. Shaw, do you also think that recovery rates for creditors in India, which historically have been very poor, also need to be changed?
No, I absolutely agree with that. Basically, I think our judicial processes are so slow. And I think adjudication also is not a very efficient process in this country, that it takes forever, and by the time you actually recover or settle, this is what the metrics look like. So I think yes, there needs to be a far greater law enforcement, judicial speediness, and I think we need to get serious about how we deal with these kind of issues, because I think banks also need to make sure that they are, they track the kind of debt that they're getting into, because it's going to be very difficult. You see, I mean, there's one provision of this bill which is about making public the list of defaulters, which is all very well, but I think the more important thing is how do you sort of get defaulters to start paying back sooner than later.
Ms. Shaw, so are you making a case that the bankruptcy bill is more like a tiger paper? It means a lot, the intention is fine, it's a landmark, but the ultimate objective will not be achieved?
No, it can be achieved. Please don't get me wrong. But I think, like everyone on this panel is saying, the devil is in the detail, the devil is in the implementation. And I think it's not such an easy thing to implement something as complex as a bankruptcy law. I think we need to get all the systems and mechanisms in place before we start, unleashing the power of this particular bill. I think it's important for us to get expertise. It's important for us to get, domain experts in this particular area to really tell us how to implement it. Because this is something very new to the country. And I think, we don't, or we at least have to assess all the mechanisms that are required to make it effective.
If I look at the Indian banking system per se, Ms. Shaw, there are two type of borrowers. One who have genuinely borrowed money and they are stuck because of a cyclical problem, the cycle going wrong, downtick in commodity, and then there are promoters who have abused and misused the system. Now, this bankruptcy law does not differentiate there. I mean, a borrower is a borrower irrespective of the intention. So, how does one resolve that problem?
Yeah, but the same holds good in any part of the world. Insolvency is not about taking, subjective views on insolvency. If a business cannot continue for a certain period of time, for whatever reasons, it is considered to be insolvent. I mean, I myself have been the beneficiary of a company going insolvent in the US, a biotech company going insolvent in the US, and I was able to acquire all its assets. But you have to come to a point where you try to continue, and then the moment you cannot, irrespective of what the reasons are, you are declared insolvent or bankrupt, and then you file for insolvency, and you basically free yourself of this particular obligations, and then you can start all over again. This is what the whole Insolvency Act is all about. So it's not about then sort of saying, look, maybe we need to give this person more time, and maybe we need to see whether the cycle will change. That's not what insolvency is about. Insolvency is about an organization which gets to a point that for the foreseeable future does not see any hope of revival or reviving itself into solvency. So I think we need to be very objective about this bill.
I think it's probably also difficult to do the latter. But Ms. Shaw, just changing this scope a little bit, somewhere a few people believe that because of the security that will also be given via this code to the unsecured lenders, it has, in a manner of speaking, the ability to, broaden or widen the depth of the bond markets existing in India as well, maybe the corporate bond market. Do you think it is stretching it too far, and will this happen a bit too later in the time cycle, or can it happen immediately?
I think if you look the world over, I think there are very clear set of norms that guide insolvency and bankruptcy laws. And I think it basically gives, there's a tiered approach to who gets the first lien and so on and so forth. And I think that's the way you have to look at it. I don't think we should be now, taking a different view of such things. I mean, it's not that India is the first country to be enacting an insolvency law. I think we must basically gain domain knowledge and expertise from countries who have been doing it for decades. Many countries have been doing this for a long time, and they have legal experts, they have various types of domain experts whom we should actually learn from.
Find us on Facebook at facebook.com/etnow, and don't forget to click the like button. You can also follow us on Twitter at etnowlive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/etnow.